Hello, hello. Happy Friday. Gosh, the end of January. What is happening? How is it January 26th already? Happy Friday. We are here to stream in Idaho whenever that hearing starts. Replay crew, love you. Everything will be time stamped down below. We are covering the State versus Bryan Kohberger hearing in court today. Hopefully, we're going to get a scheduling order and hear when this case might go to trial. Hopefully, we'll see what's going to happen with this interlocutory appeal, which just means an appeal that pauses the current proceeding and goes up on appeal and then comes back down. If that happens, this case is going to drag on a lot longer. And we're gonna see what happens. There was a sealed hearing this morning that we know nothing about. There was a Murdaugh hearing this morning that's embargoed essentially until Monday. So nobody who was there can talk about it till Monday. So we're gonna do that on Monday. There's more stuff going on in the Murdaugh case. And if this hearing doesn't start, maybe we'll just do that. So I'm going to answer questions. We're going to talk about kind of the road so far with where we are. Thank you all in the chat for the love for WFLA. It was so good to see so many law nerds. We definitely bumped WFLA into trending with all the law nerds that were there watching. So thank you. I always enjoy talking to JB. I think he's a great journalist. I love what he's created with the Stream Center. I think they're making news more accessible. And I love that he enjoys engaging with the community. We are here to help bring information in a way that people can digest and hopefully enjoy. And that is his mission with the news. That has been my mission with the law. Mostly pop culture. There's a new housewives lawsuit today. Like today, Friday is popping off in a way that's uncomfortable. I'm like, can you chill? Like, it's the weekend. Can you chill? It's Friday. Let's chill. I saw this question in the chat. Hold on. First, how is Griffin? He is doing much, much better and feeling much, much better. I see all the happy birthday love to Runkle. Absolutely happy birthday to Runkle. We will talk about Runkle's stream for tomorrow for his birthday stream. You all should check that out. Does trial start today? No. There may be a scheduling order today, and we may find out when trial will start in the future if they aren't given leave to appeal. If the defense is given leave to appeal, it will stop the criminal proceedings while the appeal is pending. So we're going to find out what happens with that. So chat, we're going to get into some questions. Members, good to see you. Y'all, let's just roll the intro. Like I did my hair today. Let's roll the intro. Let's get into it and do all the law nerdy things. Let me know where you're coming in from, what you're drinking. It's 3 p.m. and I might leave my house later today. So I'm drinking water and water. We have like water and backup water. That's exactly what we're doing. So let's roll the intro. Where you're coming in from, what you're drinking. Let's go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not. Let's get into it.
Oh, Sophie, that would make me nuts too. Sophie said my neighbors are playing the loudest music. I can't cope. That would make me nuts. I hope you have noise canceling headphones. I can't with sounds. D Sam, glad you're live. I'm drinking nothing. All I want is Wingstop. For those of you that are new here, welcome. We're going to get rolling whenever this court gets rolling. But right now, you know what court's not doing is anything. There's not even a placeholder up. It is. Here, let me make sure my screen is shared. Emily, do the basic things. Share the screen. Nothing. So I will move that into a bigger screen later. January's coming in from Baltimore, drinking water. It's a hydrated chat. We stay hydrated. We stay glowing. It's what it is. It's just what it is. All of you, the international crew, good to see you all over the place today. So I'm going to answer some questions. We're going to do a quick road so far with where we're at with this case. And we're going to wait for this. We're going to uncomfortably wait for court to start because it would be great if court would start. And the court order has blocked journalists from live tweeting. So we're not even going to see anyone that's in the courtroom saying, hey, court's getting ready to start. We're just not going to know. And I find that deeply uncomfortable. I don't like just not knowing, but there's nothing happening on this YouTube channel, and that is the only way we're going to be able to access the live stream, and it's very frustrating. There are no cameras in the courtroom from the media. Let's do a quick road so far and then answer some questions. So if you guys have questions, please put question or a Q in front of it so I see it, or even a question mark, and we'll go from there. This is a great example. I just saw it. This is a great example. Q, is there an appeal right now? No, but they are asking for leave to appeal, and we will see what the judge does with that, but it makes it very easy for me to see your questions, distinct from saying hello. Addie's like, why will my video not load me watching this court in Utah? I don't know. I keep refreshing. I know Miguelina is refreshing. I'm sure the chat is refreshing. We are all just sitting here refreshing. It feels like an Apple iPhone launch, which is a weird feeling when we're waiting for a court hearing to start. New update on Murdaugh. Yes, McCoy, there is. I don't know if we'll be able to get to that today. There's just a new filing from the defense, and court starts bright and early on Monday, and we're going to start in court bright and early on Monday. Is this audio only? No, it should be video through the court. So I saw the court doing a test stream, and it was a video camera facing into the courtroom. So the two counsel tables and like the lectern, and then a camera facing like where the judge and witness stand is. And it was an empty courtroom, and they were doing a stream. And that's what I saw them practicing. So the chat's all saying it's live. Let's see. I don't have it live on my end. Oh, there it is. All right, let's go to court right now. I'm going to pause this. It's been live for like 40 seconds. Chat, you are bae. I'm going to keep that paused real quick. I'm going to do a quick road so far. Let's go to Idaho. All right. Chat, I'm going to keep your questions till we get to the end. We are going to go live to court. This is the first time that this court is doing court via their own YouTube channel. Remember, Judge John Judge kicked the media cameras out of the courtroom, absolutely yeeted them, and said, you know what? If y'all aren't going to follow my order and you're going to zoom in on the defendant's face and the rest of it, yada yada, you're not going to get to do this. I'm going to do it myself. And that's where we find court today with John Judge saying, I'm going to do it myself. So let us go to court in Idaho. Emily, how about you add it? Emily, what are we doing? We are professionals here, folks. And this is fussing with me. So give me 1 sec and we will head into court. It is a very full courtroom. And we will go there in just 1 second. I was all prepped to share screen. Being a live streamer is always the best because it is unpredictable and we get to think on our feet. It's just like being in court myself. All right. I'm gonna be down here. We'll see how that goes. If we're blocking somebody, I will change where I'm going. So chat, let's go to court, shall we? All right, let's do it.
Just a minute. Thank you. Sorry for the delay.
Thank you. You stressed us the fuck out, John Judge, but we're good now. We're okay now. I'm blocking somebody. There we go. Try not to block anybody's face. Here, let me adjust this real quick. There we go.
Okay, great. All right, thank you. Let's get on the record, please. Okay, we are on the record. This is State of Idaho versus Bryan Kohberger, case number CR 29222805. We have Ms. Taylor, Ms. Logston, and Ms. Massa representing Mr. Kohberger. Ms. Mathis is remote.
Remember, the court has said that if we do anything to crop or to zoom in on where Kohberger is sitting, it violates the court order. So I am not going to switch screens around. We're just going to go with what we've got. This is it.
Mr. Kohberger obviously is in his courtroom. The state is represented by Mr. Thompson, Ms.
Fair enough.
Jennings, who is here also remotely, Mr. Nye, and Ms. Beatty. So we're here. This is an open case. You probably know we had a closed hearing this morning.
We're aware.
And that was necessary because that was related to the grand jury, which is secret. So that's what that was all about. I'm assuming that you've all seen the amended order governing courthouse and courtroom conduct.
I have. Thank you.
We've made some changes.
Yes,
And you probably also know that we are streaming now. And that is on a YouTube channel.
Hi, YouTube.
If you don't know that, you can go to the Supreme Court.
Y'all can zoom in on him all you want. You just can't
I guess
crop it, stream it.
website, and you can get that channel if you don't have that already. So you don't want to be on a camera.
This courtroom is.
You probably should leave. But generally, we can't see very well farther back in the courtroom. So just so you're aware of that. So today,
I can see everybody in the courtroom.
we
I can't
are
identify
addressing reconsideration of the order denying motion to dismiss the indictment. And that order is focused on the claim of inaccurate instructions to grand jury. Also, couple
the argument over the inaccurate instructions to the grand jury is the argument over the standard the grand jury needs to consider. Is it beyond a reasonable doubt or is it probable cause? It is my opinion that probable cause is the well-settled law of the land. And because it's the well-settled law of the land, this is not going to go very far. But they are asking the court to reconsider. He's probably going to say no. And then they're going to ask to pause the criminal proceedings to appeal that decision. I still think it is the well-settled law of the land, but they might be wanting the Supreme Court to restate it so there is more settled law. And if this case has to go up to the state Supreme Court, it's going to take some time.
On that is the potential for permission for appeal.
It's an Idaho
interlocutory
witness. It's an Idaho potato.
order. So, and a stay of proceeding in the case.
Interlocutory means to pause the case, and
I think that's all the preliminary. And
then appeal.
Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
This was Mr. Logston's motion the first time. Mr. Logston and Judge had a very nice time chatting with one another about this. What's interesting is today there is no lectern in the middle between the two counsel tables. Normally there's a lectern there. So Mr. Logston, take it away. So Miguelina, if you want to pin that the defense is arguing, go right ahead.
Your Honor, I'm going to, I guess, be succinct since we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has...
This is such an awkward conversation. Your Honor, with all due respect, we think you are wrong. We would like the Supremes to tell you that you are wrong. Will you please let us go over your head and tell you that you are wrong? It's like when one parent says no, and then you're like, I'm going to go ask mom or dad. Same.
Noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues, where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera. One of the major...
Sir, I'm just going to walk you guys through what he's arguing to happen. He's arguing to stop the criminal trial from moving forward, stop the criminal case from moving forward. Everything pauses. It goes up to the appellate court, so the appellate court can say, yo, remember when we previously said that the standard is probable cause? In every jurisdiction from sea to shining sea, it is probable cause. For a grand jury or a preliminary hearing, we're going to go ahead and reiterate that that is the law to you. This is not a novel issue. This is a well-settled issue. This is a reach. But he wants to pause the trial, go up to the appellate court, brief to the appellate court, argue to the appellate court, and then have it come back down. And if on the outside of outside chances, the Supreme Court says, you're right, there was an anomaly, we're going to throw out the grand jury indictment. Do you know what happens then? This all starts back over and they indict him again. That's all. We just start the merry-go-round again. So this would cause nothing of substance, in my opinion, but delay. I am not a defense attorney. I don't know if that delay helps, but all it would do is set this all back around to the beginning with him getting indicted again. That's it.
Issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one.
Yeah.
And so we believe if a trial is set out as far as we think it ought to be, that
What did you just say, Mr. Longston? What did you just say? He said, if this trial is set out as far as we think it ought to be. One day at a time, Bryan Kohberger did waive his speedy trial rights, and it seems that the defense wants to push this case out as far out as we think it should be. Are y'all looking for trial dates in like 2025? Is that what? Because it sounded like what you want to do is stall. So when I've been asked, is the defense trying to push this out? My answer has shifted based on what Mr. Longston has said. The answer is now yes.
An appeal at this point won't disturb where we think a trial should occur in any case.
Appeals can take a year. Appeals can take a year. He's saying an appeal shouldn't impact when we think this trial should start, which means they're asking for this trial to start over a year from now is the vibe that I am getting. What?
Matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left, no stone left unturned. Thank you, Judge.
Thank you, Mr. Longston.
I think both things can be true. I think the defense can need more time, and that could be them leaving no stone unturned. I think both can be true.
Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider.
He's tall.
The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact,
agreed.
The defense conceded in their opening brief on this issue that quote, the whole of modern jurisprudence on this issue is against this novel theory that they've
I
raised.
don't know.
So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation.
Yes.
I think
it doesn't materially advance the litigation. It just sets it back to the beginning. For all of you asking who are the two women at the bottom of the screen, I don't know. I think one is a defense attorney. Elisa, I believe, is an attorney in their office. Ashley might work for the court, but I don't know for sure.
We're all being honest with ourselves. A trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt.
Absolutely
we could use
it's not happening ever.
Normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today.
It would be a circle.
We need to get to a trial in this case, and that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal.
Correct.
There's and it says in F sub 2
with cameras
that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court.
Amy in the chat asked a question I think a lot of you had, and the prosecutor's addressing this directly. Can't they say the trial has to start even if there's an appeal? No. If there is an interlocutory appeal, it stops everything going on in the trial court until that appeal is resolved. It pauses everything. And he was just reading the statutes that say there is no discretion. No discretion means it doesn't matter what judge feels about it. If an interlocutory appeal is allowed and taken, everything stays by function of law. Everything stops. And the appeal has to resolve before it can move forward. So that's exactly what the prosecution is arguing now. They're arguing that this is not going to settle a new area of law, that this is not something that's likely to change substantially the proceeding. This is settled. This is not an area of law where you're like, what's happening here? The standard for pretrial determinations are probable cause. That's not new.
Losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal.
Right.
Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue. pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide.
Yep.
Under Idaho's law. Not only are those who were killed victims, but every single one of their immediate family members is a victim.
Yep.
And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. We are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
I agree with the prosecution.
Mr. Longston?
Any final words, Mr. Longston?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten.
Your Honor, can we just take a peeky peek at whether this is actually the law or not? I mean, it's the way everyone's been operating in every jurisdiction in this country for, decades on decades on decades. But we would really love Idaho to just take up whether this standard is the right standard. No.
In the maelstrom that is to come, as the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction.
That's a specific number.
The idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking that the court would forgive us.
Judge is like, tell me again about how long post-conviction appeals and homicide cases take, sir. Please do enlighten me. That's not the argument. The argument isn't you're not doing it right, Your Honor, because he is doing it right.
Permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind,
wow, they're really
just
pushing this
part
at some
of
point.
what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
I have not seen, there's new information in this, I have not seen where the state has said for sure that they are seeking the death penalty in this case. That is an option in this case, but I have not seen it filed that the state is 100% seeking the death penalty in this case and not life without parole. If this is a death penalty case, it doesn't really change much with the argument that they're making, but Mr. Longston dropped some new information saying, especially when the state is trying to kill someone. So, okay.
Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That
Agreed.
Decision was put out quite a while ago. It's rooted in wealth.
I'm waiting for Judge to be like, I've reconsidered, denied. It's denied. And we've read his order. It's very thoughtful. It is a very thorough court order denying their motion.
Settled law.
Hold on, I'm going to back up real quick because he just said it's settled law, which I've been saying this entire time.
I don't think we've done anything wrong about that. That
Agreed.
Decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but
they can do that later.
Is doubtful in my opinion.
Agreed.
We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause,
Yep.
not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12.
This I want to know.
Excuse me, let me just get this in front of me.
Your Honor, look, Your Honor, I found my rules of evidence
So,
yesterday. I'm so
The
excited.
criteria for permission to
We're all
appeal,
here.
this is in Rule 12 of the Idaho Appellate
Go to the book.
Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria.
Oh, tell me the criteria. We love a rule.
And I'll just read this part of this.
Perfect. That was not perfect.
The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion.
Okay, fail. That fails.
Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the
Agreed.
defense is making that argument. I respect that. I don't agree with that.
He's like, everyone's got a job
but
to do.
That's where this is. I don't see a
Denied.
difference of opinion throughout the state about what the standard is for grand jury determining a.
Literally no jurisdiction anywhere in the country has a question about this. This is not novel. This is not unsettled. This is not unique. The outlier would be to determine that a grand jury needed beyond a reasonable doubt. That would be the outlier. He's going to deny this.
An indictment. But this also has a second component. And this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay.
You
and
should
I
be.
think that if we send this to the Supreme Court, that it's going to add delay.
Agreed.
Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay.
10 out of 10. Agreed.
As I said, I'm already concerned about that. We're over a year.
We're over a year
Could
from
be
the time of
another
the
year.
crime.
I'll just
It could
let
easily
you all
be
know that.
another year.
Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature.
The court just buried his ruling in this sentence because he's going to get there. He denies permission to appeal. It doesn't mean they won't try to appeal. So let's hear what he has to say on that. But he was kind of burying his ruling in there. He's denying the permission to appeal on this question that is not really a question.
Yes. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment.
Unlikely on this ground.
What would happen then?
They'd
Is
get
this going to
indicted again.
really materially advance the orderly resolution of the litigation.
No, just go back to the beginning. Do not pass go. Do not
The
collect
state could just
$200
file
to
it.
start over.
Refile it, as Mr. Knight said.
Yep.
So that's significantly more
Exactly what they would do.
delay. So there's some other, actually, this is in a case law, Idaho versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties,
He's making a good
the
record.
effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional.
And this is
Seeking
not
of
that.
appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion.
Grounds.
The law is settled as far as I'm concerned, and there's no difference that I'm aware of.
Agreed.
I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward.
A very thorough record.
So I'm denying the permission for appeal, but obviously denying the motion to reconsider. And with that,
Yikes.
I think we are ready to go to
Scheduling.
setting a trial, or at least a schedule order.
Scheduling conference.
So anything else about this issue before we go to that?
No,
Ms.
scheduling.
Taylor,
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
You want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And
Cynthia, you're
to
right.
start,
This is not a surprise to them.
Mr. Lodson said something that I think needs to be
They knew it was going to get dismissed.
addressed. He makes the allegation the state is trying to kill someone here. And frankly,
Very interesting that the prosecution is trying to take a minute to respond to what was said by the defense, because we paused to talk about it. But this is very interesting. So I want to hear what the state has to say, but we're going to a scheduling conference and hopefully we will hear what they want. The defense knew these things were going to get denied. They can still try to appeal it. The court is probably going to tell them no.
I find that offensive.
I mean, they've accused the defendant of killing 4 people. I can understand why the prosecution's offended.
Yes, sir. I'd be happy to. And to start, Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here. And
He
frankly,
sure
I
did
find
say
that
that.
offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential fulfillment. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this courtroom. We would ask that that not be allowed any further.
Whew.
Now, as to the trial,
Spicy.
Ms. Niner already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year.
Summer of
We
this
realize
year.
defense has factors and considerations they want your honor to take into account, and certainly we want to afford them that opportunity. I will say though that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because
JB was saying
right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as your honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session.
can't do it during
Those are
football
the
season, Your Honor.
considerations that we have, Your Honor. As I said, we filed this last month at that time, and as we stand here today, we believe that we could be ready for trial this summer. Thank you, sir.
That's exactly what JB asked me about. Do you think
Thank you.
summer makes sense?
Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution
Ms.
that
Jennings.
we do not believe a summer of 2024 trial is realistic in any
What?
way.
Ma'am, the defense does not believe that the summer of 2024 is realistic in any way.
Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information.
The defense wants summer of 2025 and will be making a change of venue motion.
Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial, and so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that, and Mr. Kohberger decided to waive the speedy trial, and the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order, and I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial.
What?
This is, as everybody.
A 12 to, do you see Judge taking a note? A 12 to 15 week trial is what Ann Taylor just said. Ma'am.
To inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025.
Yeah,
I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and counsel to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case.
I
So
don't doubt that.
with that said, there's still plenty to do. And I want to talk a little bit specifically about that.
Tell me, what have you,
In a
tell me.
case where there is the potential for a death penalty, we're looking at two tracks of trial.
Yes.
We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen.
And Taylor, ma'am, you are just good at what you do. Most attorneys refer to the first phase of trial as the guilt phase. Being a defense attorney, she referred to it as the innocence phase. There are two phases of a death penalty trial. The did the person do the thing phase, and then the sentencing phase. And it's normally referred to as the guilt phase and the penalty phase. But she very much referred to it as the innocence phase. And if you get to the innocence phase, which it's not, it's guilty or not guilty. It's not innocent. It is guilty or not guilty. But if you get to not guilty, then there is no punishment phase because not guilty. Very, very smart in the way that she languaged that. Respect, Ann Taylor. You do your job well.
And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case. And we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted.
Okay.
And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that,
ma'am,
the court knows everything is recorded. There's digital footprints all over the place.
Yeah, there's a lot of terabytes.
And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, yeah, and we have 51 of those.
51 terabytes of data from phone dumps, computer dumps, security footage. It's a lot of data.
500 hours of high definition video. And we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge.
It is a lot of shit. Agreed.
There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that
is what?
Is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes.
This is a very, very fair point that also concerns me in cases like this. When people saw how witnesses in other high-profile cases were treated, that their businesses were review bombed, that they were excoriated on the internet, that they left social media, this is a very fair and real concern that they might want to look for a DNA expert who's like, oh, what case are you working on? Yeah, I'm not putting my career on the line here because social media might not like the way that I testify for Bryan Kohberger. I think this is a very, very fair concern because when you look at an expert like any of the experts in the Johnny Depp Amber Heard case, all of them had negative impacts for testifying in a high profile case like that. And we've seen them talk to varying degrees about that. It is a very legitimate concern because the internet is going to internet. And I worry about whether you can get the best experts to choose to participate in a case like this when they know that at the end of the day, they're going to have to sit on that witness stand in front of the entire world. And if the world does not like who they're talking to or whose side they're testifying for, that the internet might choose to go after them, their friends and family, dox their businesses, etc. Angie said, except Dr. Muffin. No, even she was run off of social media, particularly Twitter, because of how awful people were to her. Absolutely awful to her online. And that is very concerning because what you want is good experts. And good experts might just say, I'm not doing any of this. I'm not doing any of this because opening myself up like that is a mess. And it is unfortunate that we don't live in a time where people can observe and talk about their opinions over a drink with their friend and be like, that Dr. Spiegel, did you see that testimony? And instead of chatting with their friends about it or making a meme on social media about it or talking about how much he sounds like Dr. Doofenshmirtz, people sent death threats to his office and looked for his colleagues. And the same thing happened to Dr. Curry and others. And it is a huge concern. And it's very interesting to me that Ann Taylor is bringing this up. So now I'm going to shut up and we're going to listen.
We have 51 of those, or 500 hours of high definition video. And we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case.
Sometimes they might just not want to work with you and your client, but the media makes that different.
So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone.
Ma'am.
I personally...
400 witnesses. Do you see the prosecutor looking at her? 400. Are those just defense witnesses or is that John Judge, look at his face. Look at John. Judge is like, the fuck did you just say?
And my team have talked to less than 10%, well, less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to
over 500 witnesses, and she is not using guilt phase and penalty phase. She is using innocence phase and mitigation phase. It is very defense-oriented language. I think that is a good thing for her to do as a defense attorney. It's very conscientious, but just so the languaging doesn't get confusing here, over 500 witnesses. Over 500. How many notebooks am I going to need? I don't think she's exaggerating, chat. I don't. Because with 400 witnesses, if you're going to call every law enforcement officer that showed up at the crime scene, that's going to be a substantial amount of witnesses. Yikes. We'll talk about mitigation and aggravation and penalty phase after we finish this hearing. I see it, chat. We'll get to it.
Learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side, mom and dad.
What do you mean? What do you mean you're required to go 3 generations back on either side? Okay.
The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well.
I will say I very much appreciate the methodical way she's arguing to the court and trying to justify why they need more time. She is saying to the judge, and ineffective assistance of counsel is when your counsel does not do the things they're supposed to do. It's one of the main reasons cases can get overturned on appeal. What she is saying is to the judge, if I am going to be effective as counsel in a level that makes sure you can't appeal on me being ineffective, these are all the things I have to do ethically to be effective. So she is very clearly setting up, Your Honor, if you do not give us the time that we need, I cannot be effective for my client. And that puts the judge between a rock and a hard place where there's not much you can do. I mean, Judge is already like, don't put baby in the corner. He's already in the corner of that courtroom. It's an interesting layout. But she is laying out that the judge has to really go along with what the defense is asking because she can't be effective without that amount of time. And she's arguing it well.
There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery.
Not the beast.
I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this.
I like her demeanor so much. I want to know all the tea about discovery. And she's going to lean in on the state saying, I am not trying to lean in on the state, however.
I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery.
I saw that.
And there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because
if the state was indexing them on their own, it creates a whole nother layer of problems of the defense arguing, well, the state indexed this under that, so we thought it was something else. The state can't change the way they receive the discovery, because then you'd be in court arguing that they indexed thing and hid things within the indexing. So the defense is going to argue this one way or the other. There's no right answer for the state.
As we have multiple law enforcement.
What? Did they take down the stream the second that it ended? No. The hearing must be over. Oh, that's dirty. I hate that so much. Okay. Well, you know who else aired it? Everybody. Wow. Wow, Your Honor. Wow. I've been a fan, Your Honor, but don't let me start. All right, we're going to go to one of the other channels that streamed it and rewind. I know. I'm so mad. Miguelina, now we know for next time. Now we know. That's not the first time midstream. It's completely gone, you guys. Completely gone. Completely gone. You like use it or lose it. Completely gone. That's awful. It is live while it is live, and that is it. Jeez. That's spicy. All right, let's go to WFLA's feed of the court hearing and back up to where Ann Taylor is chatting with the court. It's going to take me a minute to find that and cue that up from WFLA. Let's see. All right, let's jump in here and see how this goes from WFLA. Wow, that's spicy. Damn it, court. What are you doing? All right.
That I am not disparaging the state when I say this. I'm describing.
Hey, we pulled it right up at the exact same time. That never happens. Applause, 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 applause. No, I was a little behind the live feed because I keep pausing to chat.
A complication.
I can't believe they didn't leave this up.
Probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023.
Thanks, chat.
We had some initial discovery, and then we started looking at it and asking for other discovery.
Thanks, chat.
We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file, and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities, and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are. But
yep. Yep. Half of my job as a DA, it felt like, was putting shit in binders, making an index, and then flagging everything, and then doing it digitally as well. It's a nightmare. I'm sure that you have law clerks.
You don't know which officer, and you don't know what day, because the officers were in that residence multiple times. So that's complicated to try to match all of those things.
I don't doubt that.
There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for.
We're learning more about this case now than we have in most hearings. So I am very interested in what she has to say next.
The complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video.
Yeah, that's really frustrating.
But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that.
Tech takes time.
That's an example, Your Honor, that is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have.
That is her saying, I cannot do my job without more time. That is what she's saying.
Concerned about expert reports. We have a draft of one, the CAST report. The court had ordered that we receive the CAST report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. There has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from. A few months from now is not a sufficient amount of time to do that. There is no possible way
we can even
read or watch everything I have now or react to things that are still coming in
by summer
if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a...
Ding, ding, ding. There's the word, Your Honor. I cannot be effective counsel if I do not have more time. So if you set this trial date with not enough time, it's an automatic ineffective assistance of counsel appeal. And he's already waived time. So the judge is placed in a position where he has to give them more than summer 2024. And maybe he'll say, fine, winter, schools are out. We'll do this trial over winter 2025.
Jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to.
You guys,
there is no way
I'm holding on to your questions. They're good questions.
Counsel, if I haven't looked at every bit of discovery that's available.
There's the words.
Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had this isn't a new issue. I think the court's heard about this before. We've had bits and pieces of tips, and they've come in and we've reviewed them. But the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us. But they go through other agencies before they get in the prosecutor's hands to give to us.
I meant December 2024 into January 2025. That's what I meant.
I have to read every one of those 9,000 tips.
Someone on your team does.
That matter to us in our innocence phase that have come up and been done. And I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets. We constantly work. We are on this. This is our priority. Bryan's our priority. But we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the states...
They have a defense team. She does have a team. So there is a team, but she also is the lead attorney and needs to know all the things.
Motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more.
You submitted that he likes to go driving late at night by himself. That's what you submitted.
Information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be, because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date. But I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that
disagree.
Cast agents and other specialists with the FBI might.
I disagree. When she's saying that they can't come up with an alibi without going through the rest of the evidence, there's like halvesies on this for me, because maybe there's a witness, but if that witness was with Bryan Kohberger and is going to say we were together at this time, she would already know that from Bryan Kohberger. Like that, nothing in discovery should give you any more information on a true alibi that your client hasn't given you. Your client can give you the alibi witnesses. It doesn't come from your discovery. That's not a true alibi. A true alibi is, I was at this place with this other person at this time, I therefore could not have been there. That's an alibi. A defense on other witnesses and attacking other witnesses is different.
Have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that.
You've said
I wanted
that a
to
lot.
let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit.
She just got some of this IgG data. So I understand why she's arguing I need more information to know why the state started looking at Kohberger as the suspect here.
Over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions.
Knife sheath.
So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So,
sure.
And for y'all in the chat asking about Ann Taylor, she is a tremendously experienced, seasoned, and death penalty certified defense attorney. So this is not her first rodeo at all. And you are seeing that in court with how methodical she was going through and establishing to the court that to be effective, essentially to meet that standard of effective assistance of counsel, she needs more time.
I understand this. I mean, I'm aware amount disclosures.
I am aware of the amount
already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If
she's like, go ahead, Your Honor. The prosecution can't get it. We can't get it. I don't know what you can do to make it go faster, but we still have to index shit.
State says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you.
It never does.
And the records you need will be given to you when you ask. And the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then
You can never make that happen. You cannot force people to speak with law enforcement or the defense. These things can't be made to happen.
I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays.
Which you've already
getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025.
Wow.
I'm nervous telling you that.
Wow. Wow.
This is priority for everybody. And I want to be realistic about it. I don't want to set it more than once. I only want to have one trial.
That's not realistic either. Judge said, I don't want to set this more than once. So he is going to set it out further. But she said, for everything to go perfectly, I'm still nervous to tell you I will be ready summer 2025, which means they could get closer to summer 2025 if that's when he sets this, and then come in and say, we still need more time. So the judge is also like, this is a priority, but what can you do?
So it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair.
So for the chat that has been like, is she exaggerating this? The prosecution is co-signing what she has argued, that there is no limit to the amount of work this is. And that is telling.
Say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together.
Yeah, that's
the tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, all of which need to be looked at.
Most of which are out there, and that's true with a high-profile case. You're going to get people calling the tip line just to call the tip line because they want to call the tip line, or you're going to get people saying they were a spiritual witness and they're calling the tip line to leave their tip. But the defense has to go through all 9,000 tips in case there was one or two that point to someone other than Bryan Kohberger. So it is literally a needle in a haystack.
To see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration.
So the prosecution's
with the high school,
acquiesced.
with the universities.
They have acquiesced.
We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the
Kohberger's
community
in custody,
that cause
yes.
issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international.
Changing venue is not going to change much. Unless you can get a bigger courthouse with more space that's less disruptive to the local community. Changing venue is not going to help too much.
Attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who.
Can someone invite me to a meeting in McCall? It's lovely. Let's have some of the conferences I need to go to there instead of Vegas once in a while.
Traveled to Mexico, and they say people here were from Moscow, and immediately they want to talk about this case. It's not Moscow. It's not Latah County. It's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. Mm-hmm. And not just rely on, there's been a lot of publicity. Mm-hmm. There's been a lot of publicity everywhere. Mm-hmm. The only place I've heard there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention co-location. Said, "What are you talking about?" So if we want to change venue, I guess we could go to Nez Perce.
Where's Lewis County, y'all?
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Yeah. Thank you, Mr. Thompson.
Thank you, Mr. Thompson. Y'all, don't forget to do the YouTube-y things. I'm just going to plug that for a minute because I have not asked. Like and subscribe. We're pushing towards 750,000 subscribers here on YouTube. And don't forget to download the Lawnerd app at lawnerd.app.com because we're going to be streaming court all next week. So if you want to stay in the loop on what's going on in court in South Carolina next week, you need the Lawnerd app. Thank you, Nightbot. You had your moment.
So you're saying, looking at this realistically and the amount of information, evidence, non-evidence.
Yeah, the prosecution's agreeing.
That might be looking at summer of 2025.
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families.
Of course
they have suffered for well over a year now with a lot of uncertainty. And that's painful. It's an everyday reminder, and they need some certainty. And
I will just offer that it will be worse to go to trial and have this case turned over on IAC because Ann Taylor told you she needed time to get ready and you didn't give her time to get ready. That's worse. That's worse. But this is terrible for the families. Not knowing, not having a date, not being communicated with is awful. Hopefully having a date will help. Having a date so far out feels awful. Having a case having someone convicted and then overturned on appeal and then having to go through this trial again 8 years or more down the road is worse.
They need some closure in a timely fashion, but we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once.
Yes.
That it doesn't come back on appeal, that doesn't come back
The prosecution acquiesced.
or subsequent things saying that somebody made a mistake.
Summer
we want to
2025.
do it right.
Summer 2025.
And if the factors are in front of Your Honor, I think that
That
you're certainly in a good position to make the best decision.
That sucks. It might be the right
It's a decision
result.
that pulls me in two different.
Your Honor,
I appreciate that, Judge.
Samesies. Because the judge has to decide what's going to protect this case on appeal, knowing that the right solution sucks. It fucking sucks.
I want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe
you don't
March,
have much of a choice.
2025, which Taylor, that would be a reach.
It'd be a push. Yeah, he stays in jail. He stays in jail till this is done.
Percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly.
The problem is that brains only move so fast, and there's 50 terabytes of data and witnesses that have to be gotten. Like, your brain can only do so much. Like, you can only do so much.
I'm not going to just let it hang for too long. But
I mean, he's going to take this into submission, I think.
It's really hard for me right now to set something in 2025.
Yeah, he doesn't like it, but he's going to have to do it.
The reality.
Yeah. Yeah, and he hates it. I hate it too.
And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions.
Mm-hmm.
Going to be a lot of motions about the death penalty as well. So
the death penalty adds months of work to this case. Months of work to this case that wouldn't otherwise be there if it was just an LWOP case.
To think that we have to have a case so far in the future. But if that's what is the right thing for everything, to do it correctly.
Yeah, you don't want an IAC appeal.
Maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal.
Yep.
And that's also a challenge. So
I mean, not really. Not really. That's just the nature of the case. What he's trying to say is there's no finality, even with a conviction. We're seeing this in Murdaugh. Even though there's a conviction, it's not final. These cases don't just end. We don't always follow them as much once they go to appeal, but they don't stop.
Victims, I can't even imagine the pain, the grief,
the frustration,
because you can't really go forward with your life without this hanging over your head. So, sorry. We'll see. All right, so
he's taking that under submission.
I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently.
He's like, it's not like we're starting anytime soon.
I want to do the right thing.
Yep.
So, Does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay, Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
I'm going to get to questions. Court's adjourned. Judge Judd's literally walking off the bench. I'm going to leave this court feed up real quick. Actually, let me do this. I'm going to leave the court feed up real quick as everybody's walking out. Let me just put me back here as everyone's walking out of court. But this is the end of this hearing. I imagine live. Oh, and that's when the court feed cut, and then WFLA went back live. All right, we're going to get to questions. There's tons of them. I've been collecting them as we've been going through the chat. I was so frustrated that court feed cut right in the middle of the freaking feed. Like, what are we doing? For those of you that are new, hi, go ahead and put a 1 in the chat. If you're just finding me, I'm always fascinated when we have new law nerds that are like, hey, girl, is this what we do all the time over here? Yes. Yes, it is. Let's take a breath. We're going to do a summary real quick, and then we're going to do Q&A. Here's what happened today in Idaho. Judge John Judge had an entire hearing sealed to the public regarding the indictment of Bryan Kohberger. Then in the public hearing, he heard a motion for reconsideration, which is the defense asking the judge to reconsider his prior ruling with regard to the standard of proof needed for an indictment. The defense is arguing that the standard of proof a grand jury needs to indict is beyond a reasonable doubt. Judge Judd previously ruled, like every other court everywhere in the U.S., that the standard is probable cause. Same for grand jury, same for prelim, same for pronouncement by judge. Probable cause. The defense asked him to think again about that, Your Honor. Would you please reconsider and change your mind? The court said no. Then they asked for leave to file an interlocutory appeal. An interlocutory appeal means during the proceedings of this case, the entire case would stop while that question goes up on appeal, arguing from the defense that this case cannot move forward until that decision is decided. The judge said, yeah, we're not doing that either. This is not a unsettled area of law. Literally all the courts agree. You're the only one that disagrees with this standard, and we're not going to do that. Will the defense perhaps still try to take an appeal up to the Supreme Court of the state of Idaho? Yeah, probably. Is that going to go very well? No, not really. This is not an area of law where it's like, well, they have a strong argument. No, they don't. No, they don't. This one is an absolute reach. They've done it respectfully. They've tried to argue that the Magna Carta set a different standard for juries because it's a grand jury and it should all be beyond a reasonable doubt, but that's not going to fly. That is not the law of the land. Then they got into a scheduling conference that was respectfully argued, but difficult. The defense is saying that there is no way that they can be ready for trial in this quadruple homicide before the summer of 2025. Sometimes I misspeak as to dates, but you heard me correct on that one. Summer of 2025 is when the defense wants to set this trial. The prosecution argued this trial needed to go to trial in the summer, and it needed to be summer of 2024. Ann Taylor did an excellent job of thoroughly laying out the fact that she could not be an assistive and effective counsel for Bryan Kohberger without that much time. And she is setting up the argument on appeal later that if she is not granted that much time, that her argument will be ineffective assistance of counsel, or the appellate attorney would argue ineffective assistance of counsel because she said she needed that time and was not given that time. Ineffective assistance of counsel can be strong grounds for appeal after conviction. She talked about how much work is needed to be done in the penalty phase of the trial and how much work is needed to be done in the guilt phase of the trial. So the first phase of this trial will be, is Bryan Kohberger guilty or not guilty? And the second phase will be, and then what punishment? Life without parole or the death penalty? She talked about how much work goes into both of those phases and indicated that combined there could be over 500 witnesses in this case, and that she believes this trial is going to take 12 to 15 weeks of trial. And with that, we're going to get to your questions. The judge did not make a decision in Idaho and wants to take it into consideration, considering that these murders took place over a year ago, and the delay and the stress that delay causes on the families of the victims. However, if the defense does not have effective assistance of counsel, that is an appeal that could cause any conviction to be overturned in the future, meaning that justice will not be settled for the victims' families if that happens, putting the judge in a position that he does not like, because even the prosecution started to acquiesce that this trial might have to go to trial in summer of 2025, which is likely what the judge is going to do. And with all of that, let's get to your questions. Grass folk in the chat said 400 witnesses. I thought she said not 500. She said 400 in the guilt phase, 100 in the mitigation phase, which is what she called it. Let's talk about that language really quick. She called it the innocence phase and the mitigation phase. I call it, former prosecutor, the guilt phase and the penalty phase, the punishment phase. The reason she called it the innocence phase is because, again, she is a defense attorney. She is arguing with everything she says for her defendant, and she is not acquiescing to guilt in any way. I thought it was very conscientious. She called it the mitigation phase because at the death penalty phase, or at the penalty phase of a death penalty trial, the prosecution argues for aggravation, taking the case from life without parole to death, and the defense argues mitigation. This is why you should grant him life without parole and not the death penalty. So she argued mitigation, or called it the mitigation phase, with all of the languaging with that. And I think that is incredibly mindful, but hopefully that helps you understand, or helps you understand what her language means. So she was also talking about how difficult getting witnesses is because of the media in this case and the media attention. And I think that's because we've seen expert witnesses maybe not be treated the best by, the internet and the greater world, depending on the case. We have seen this. I mean, it seems like courts have become kind of reality TV, and there are the heroes and there are the villains. And instead of just having people have their opinions, which all of you are entitled to, instead of people having their opinions and talking about it with their friends and their community, there is a next phase that people go after. And that next phase is brigading people's reviews on Google if they own a business, sending them death threats in their DMs, running them off of social media. And I find that behavior abhorrent. I don't think it should happen. I don't know how to tell people, just have a conversation with your friends if you don't like somebody. But you don't need to tell that person that much. And I understand the concern. Like I understand the concern. And she's not wrong. It is a concern. And I think we're going to see a time when courts are like, you know what? We've gone too far with this transparency thing. We've gone too far. We can't get good witnesses and expert witnesses in cases because of the harassment they might be subjected to. And that's bullshit. Have your opinions, fine. But when did it become okay to just get behind a keyboard and threaten people and try to run them off of social media and try to ruin their business because you don't agree with what they said or how they testified or what side they testified for? It's just a problem. Just a problem. And I think that the defense really argued that problem in court to bring it to the court's attention. So, is there ever enough time for defense to prepare their case? Yes. In a case like this, it's going to be a problem. There's a lot of information here. Just a lot. Just all. It's funny. My Libby, my son and I were talking about cancel culture today in the car. He is studying Socrates, and he was talking about how he's like, look, people disagreed with Socrates and then they killed him. Like, so we were talking about other historical figures that had new ideas that maybe went against the popular culture or the popular ideas at the time, or went against the church, depending on who we're talking about. If we're getting into like Galileo at all, but we were talking about the historical, was cancel culture just, murder? And it was a very interesting conversation with my teen about how MLK, we taught, yes, JFK as well. So this is what we were talking about, how people handled that when their viewpoints were challenged. And it was a really interesting conversation, seeing my kid parse through what he's seeing in the world today versus what he saw from thinkers in history that challenged people's perceptions and ideas, and that people were just like, okay, well, we're going to assassinate you. Abraham Lincoln, same. So my dude's so great. Thank you, RK. So this was the conversation that we were having in the car today. I was like, it's very early. Like it's very early. It's very early. So that was the conversation that we were having this morning. And it's hard because I feel like we've evolved as people, but then there's time you look at it and you're like, oh no, the internet will still sometimes just be like, that's a weird thing to live through, because sometimes the internet feels like the Coliseum, and the internet's like, we're going to vote down. We're just going to vote down. And that's a strange phenomenon to live out in different ways. So hopefully less death, right? Even less death threats, please. Okay, let's get into the rest of the questions about this case without me going through those in history that have challenged a thought and opinion, and people have found those thoughts so outrageous that they could not speak them. Whenever people try to shut down conversation, it ruffles me very much. I think ideas and conversation need to be explored. Yes, Joan of Arc as well. I love the chat. My name is Sigmund, but you can call me Ziggy. I majored in philosophy and wrote a paper on Socrates getting canceled. Jasmine, this is kind of the direction we were going in. I was like, Trav, at some point you should just compare cancel culture to historical figures. I'm sure there's a million PhD dissertations on it. Joan of Arc was canceled too and threatened for cross-dressing. Yep, this is putting a whole pin on it. Threatening the church did not work well. And for those of you that are like, are we now back at the Roman Empire? Yeah, yes. Grass folk, yes, absolutely. Most witches were just outspoken women, yes, because how dare they with their women brain have opinions, right? They're just like, how do we know if she's a witch? We'll see if she floats. We're going to get to Monty Python real fast. We're going to get from Bill and Ted to Monty Python real quick here in the chat, and I appreciate it. Anyway, so that was the full circle. All right, let's see. Like a duck. Who were the two women at the bottom of the hearing? A prosecutor and a defense attorney that were not present in court. Let's get to questions. Campari's mom said you rocked it today on WFLA. I'm a WFLA local. We love you, JB and Emily. Thank you so much. I had a really lovely time chatting with JB. And you know what I'm feeling this afternoon? Hopefully it's not annoying to you. I'm feeling a little StreamYard music, because StreamYard lets me stream the way I stream here. I could not do what I do without StreamYard. I started streaming because StreamYard made it so easy. But I'm kind of like, I don't know. I kind of feel like maybe we just need Q&A vibes today. It's been a while since we've had Q&A vibes, but it felt like we needed Q&A vibes. All right, now we've got our StreamYard Q&A vibes. Emily, I was so proud of seeing all the purple hearts. Your app works and we ride. Thank you, Mike. The app did work. So for all of you that got the app notification, you didn't miss me on WFLA because you knew, because you had the app. Pat Yoga, good to see you. Thank you for the gifted memberships. Members, if I don't get to all your chats, I promise I read them after the chat, but I don't know if I will get to them. Cornish Len, great start to the weekend. I think so too. Oh, how time flies when watching EDB. This court case was thorough today. Sending love from Chicago. Thank you, Christina. Will you be on Runkle's birthday Supreme Court live stream? I think that's tomorrow. I do not know. We've got some kid stuff. I need to look at timing of kid stuff. I've literally not looked at my calendar. This week I have streamed. Monday I recorded the podcast. Tuesday we streamed. Wednesday podcast and members only streamed. Thursday we streamed. Today we streamed. And I'm streaming Monday, Tuesday, Wednesday. So we've got a lot coming up. And so it's going to be a lot. But I have to take a look at my calendar because I know we have some kid stuff. Kate said, "Hey, Emily, longtime silent watcher, love your content and merch. Was wondering if you could wish my husband, John, a happy birthday." Happy birthday, John.
We hope it's a good birthday, John. Don't forget to go celebrate on Runkle's stream too. Yay!
Let's see. Kim said, "I have been looking long at old members only streams. Did you ever get that iridescent lips phone? If not, I'm buying it and sending it immediately." Kim, I keep meaning to order one. I have not. I got distracted because I got the bear brick from YouTube and I've been so thrilled about it. I have something else I have not put up in the background either. Hold on. It's on my desk. I bought myself something ridiculous. And it's meant for the background. A friend texted me this and said, "Did you know this existed?" And I said, "No." And so she texted me and I ended up buying the most ridiculous thing. But let's get this out of here. Oh my goodness. Emily, what's going in your background next? A Crystal Eevee. A Crystal Eevee collab. Because how good is Crystal Eevee going to look in the background? Emily, are you a child? Yes, but with a credit card and neurodivergence. So Crystal Eevee is going in the background, and the lips phone is meant to go in the background. But this Crystal Eevee isn't it so good? Isn't it so good? It's going to pick up the light. It's going to go by the bear brick. Eevee is my favorite. Like, Eevee's like, "I'll be all things. You want me to be a water bitch? I'll be a water bitch. You want me to be a forest bitch? I'll be a forest bitch." I love Eevee. All right. Anyway. I don't trust adults that don't buy toys. That's where I'm just at. Like, if you're an adult and you don't buy yourself toys, I don't know what we're doing. Our toys just get more expensive. And sometimes you just put your stuff in them and carry them around and it's called a purse. Lawn nerds are my favorite of all the nerds. Same, Sarah. Same. Happy to spend my 1-year lawn nerd anniversary with y'all. I love it too. Saturday morning, best time for a live stream. Hello, Australia. Hello, Mary Ann. Will you cover the Frankie Hildebrandt sentencing? Yes. I don't think it's going to be streamed, but yes, I will cover it when I have the footage. Lost my coat and said it's under seal. It is under seal. Can't find it. It's 4 p.m. White Claw vodka soda pineapple sounds good. Do I stay up and watch or read? I don't know. Watch and then read. Hydrate or dihydrate. That's fair. This is the pretrial that never ends. Yes, it goes on and on, my friends. Yes, it does. Yes, it does. Water, work for a few more minutes, then Costco. Costco after work is a whole adventure, especially on a Friday. Mug of the day. Don't have a mug of the day today. Starbucks cup. G Mommy said housewife lawsuit today. I have not even had a chance to pull up the housewife lawsuit today. I saw that we have a housewife lawsuit, but I haven't pulled the documents. It's gonna have to happen next week. Murdaugh's going to court on Monday, and we've got all the juror questions and all the things. Judge notification just popped up. Thank you. Good evening from Scotland. Good evening, Sandra. I'm confused. No cameras, but I thought it was live today. Also, how can they enforce no live tweeting? Are folks not allowed to have phones? If you are in court, you cannot live tweet. But if you were watching on the interwebs, you could live tweet. So there was no live tweets from the courtrooms because no one in the courtroom was allowed to have their phone. So that's how they're enforcing it. The court's like, I imagine that the court's perception on this is, I'm streaming it to YouTube. If you want to live tweet, go sit somewhere and watch it on YouTube. Go sit in the overflow room, but you're not going to have your phone out in court. New feed audio is still sponsored by Idaho Potatoes. Will the families be present in the courtroom? Linda, they have not been. They've generally appeared via Zoom. I don't think they even need to appear via Zoom. I think they can watch it directly from the court's website, and that's probably what they did so they could stay home. Lori said, is all posturing, Emily. The defense is doing everything they can to stall this trial. The defense needs more time. And there some of it is, and she said, we're not stalling, but we do need more time. They need more time. And they ran up right to the deadline to say that he was waiving time, and then he waived time. Surely a grand jury has to be probable cause. If it was beyond a reasonable doubt, then what's the point of a trial? JJ? Yep. Yep. How would pushing the trial 2 years benefit Bryan Kohberger? The more time his attorneys have to prepare, the better. And the state can run into witness issues. The more time that happens, the more things can happen. Memories fade. Eyewitness memory fades. It's much easier to cross-examine a witness and say, yeah, but this was 4 years ago. How well do you really remember that? How exactly do you remember what you saw? The farther away you get from the event, the easier it is for the defense to challenge memory and to challenge law enforcement memory and to challenge the rest of it. So sadly, witnesses, the longer you go out from the thing happening, witnesses can pass away. Witnesses in your chain of custody can pass away. Witnesses can retire and move out of state or move out of the country. The longer it goes, the more you can have witness issues, and the more that they will argue, yeah, but how accurate is this? So the farther out the trial goes, the more you can poke holes in doubt. And that is their job. Their job is to poke at doubt. So thanks for keeping me company at work today. You are welcome. Proud honored for 18 months, sending love from Australia. All the Aussies in the chat today. This time worked for y'all. What about justice for the victims? How about that? Wowie zowie. I pulled this up because not only did I see a ton of comments like this, but it's something that we always need to talk about. The defendant's constitutional rights come first and foremost in any trial. Some states have victims' rights acts, but if the defense attorney says they cannot be ready, no matter how delaying and frustrating it is to the victim, those rights are always going to be superior because that is the person who is being prosecuted. There was a very long period of time in our jurisprudence where there weren't victims' rights statutes at all. And the victims are not always considered first and foremost when these arguments are happening because they don't have a right to a speedy trial. They have a right to have justice play out in a reasonable amount of time, but the defendant has a speedy trial right. If the defendant waives that right and says they need more time, it doesn't matter truly how much the victims say this is horrible for us, because if the defendant's attorneys say we cannot be effective assistance of counsel, then if they push them to trial, it can get overturned on appeal, and that's worse. So it is considered, but it is not the thing that reigns supreme when you're looking at constitutional rights bumping up against each other. And that's very frustrating. Very frustrating. Angie asked the same question. Don't the victims' families deserve speedy justice? They do deserve it. It doesn't mean that that's what's going to happen. Thank you very much for covering this hearing. You're welcome. Absolutely. Witness said, what do you mean settled law? It is well decided. So the press cannot print a zoomed in picture of Bryan Kohberger at all. Yvette, that's what the order seems to say, that the press can't like zoom in on just his box and digitally enhance it and share it. That seems to be what the court order says. Eliza said new courtroom angles. The court was streaming this to their YouTube channel for the first time. So yes, new angles. I liked the angles quite a lot better, honestly, because we could see the counsel tables and who's arguing. It's not close, but you can see it. You get a close-up of the judge's face and reactions, and then you saw the two other attorneys down at the bottom. Let's see. Question that allow him to be out in public will appeal. Alexis, even if he's granted right to appeal, even if he gets an appeal, he will not be out of custody. Question, why would Kohberger want to delay in custody to have more time to prepare? More time to prepare, to have effective assistance of counsel, and because things happen. You know, I don't want to wish this on anybody, so it's hard to give examples, but if the lead detective on the case had a heart attack or a stroke or got hit by a car or something else, it changes the case. More time benefits the defense more than it benefits the prosecution. Can they have zoomed in footage post-trial like in a documentary? if the court changes their ruling, but I don't know if they will. Let's see. Wouldn't depositions allow facts to remain intact even if witnesses aren't busy? Most criminal cases do not have depositions. They have interviews, but they do not have depositions. So it is not the same as civil, where things can drag on from 5 years, and it's just like, play the deposition from 5 years ago. In criminal cases, you have the right to confront and cross-examine witnesses against you, and they need to be presented live in court. Stephen, always good to see you. Get to see EDB and some RGB all in one day. RBG, I do that too. I'm a fan. I'm fangirling over Eliza's background. Was RGB an influence for you? We can talk all about all the Supreme Court cases I read, but, you know, seeing women on the court and how they argued and how they maintained friendships with those they disagree with is always inspiring. And also watching the journey through being on the highest court in the land and being a mom and is tremendously inspiring. Judge Murdaugh says should be done by Monday. We'll see. Yes, this time works great for the Aussies. I'll keep that in mind when we need to push things back for afternoon court. Murdaugh starts bright and early on Monday, though. Does Ann Taylor still have other clients? It is unlikely that Ann Taylor has many other clients, but probably a few. Most defense attorneys do. Sally says their posturing when waiving time is disingenuous. I appreciate your opinion. Been a month after a free membership. It's been a blast. So glad, JoJo. Wait, what is happening on Monday with Murdaugh? The hearing with the courthouse Becky and with the jurors. Please cover Miles Davis photography, Kat Von D fair use trial. I will cover it when it is done. We'll go back and break it down. I don't have time to cover it concurrently with everything else that we've got going on. I really wanted Judge Day to take slow sips from the mug while staring at the defense as they gave their argument. Beldy is a Housewives fan. Same. It's the new power move. Sip your tea from your mug while you stare down your opponent. Angie said to me, it seems the defense is really just going to scrape up as much time crumbs as they can. It makes me think their case is struggling. There are some very legitimate concerns about how much information the defense has. That cannot be understated. It is legitimately a concern. It also benefits them to take more time. But the prosecution stood up and co-signed that, saying, look, Your Honor, it really is a ton of shit. And the prosecution's been fighting with like the FBI to get stuff turned over. So the prosecution didn't say, Your Honor, this is all bluster. Don't worry, a prosecution will do that if they feel that way. They said, Your Honor, that it really is a lot of stuff. Yeah, we get it. Anya said, love learning law with you, Emily. Thank you. Casey, almost a whole year. Congratulations. 37 months, Smarty. Me. Congratulations. Renee said, I'm behind, but this B is straight up going to back to the Magna Carta and on his ancestral line. I mean, that was the argument. B, also coming in from Australia. EDB on my Saturday morning. Love you. Love you too. Happy Saturday to all. Y'all, we need like an Aussie branch of the fan club here. I need to come to Australia. We need a meet and greet. All the Aussies are up in the chat. It's like Aussie, oi, 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 or something. Tamara said, with the prosecution agreeing to the defense, it sounds like 2025. Yeah, the prosecution acquiesces. Yellow Pill said, we're going to need a luxury Airbnb in Idaho. Yeah, we are. Yeah, we are. If we're going to be there for 15 weeks. In the summer, oh my God, my band touring schedule is going to be totally fucked. Dr. B is going to be like, what are we doing summer 2025? Nothing. CJ Chaos, I wonder if the TikTok psychic left a tip. The TikTok psychic did leave a tip. It's come up in the court filings. The TikTok psychic absolutely left a tip. Absolutely left a tip. It's been in multiple of the court filings in that case. Emily Outdoors, good to see you. Question, can the court impose any sort of limitation on the length of trial? Not in a criminal case. Not really. When the attorneys say we need all of this, the court can limit lines of questioning. Like the court in Murdaugh could have limited and did limit some of the financial crime information and stuff like that. There are things the court can limit, but the court can't really say, I know you said you need 15 weeks, you have 3. Not in a criminal case. Civil case is different. Can you imagine asking jurors to give up their entire summer? I can, but it sucks. If there's a change of venue, does the judge change? No, the judge generally will go to the other venue unless there's a quirk in Idaho I don't know about. If both sides agree, the judge has no choice, right? Gringa, the sides can agree and the judge can disagree. At the end of the day, the judge is the judge and the judge can do that. Teresa said, question, if this actually is a 12 to 15 week case, how do they get jurors willing to sit? That's almost 3 months minimum. It'll interfere with school year regardless, right? It's a challenge. It is a challenge to get people to sit that long. I think OJ was like 6 months and they had jurors. It is a challenge. But they will find people. They will often heavily lean in. You end up with a kind of unintentionally, but you can end up with a high percentage of government employees because their employers can't do anything. It's like, I'm going to be on jury duty for 3 months with deuces and they get paid. So you can end up with a high percentage of government employees on the jury. Are they in the same courtroom as prior times? Lights so much better, audio billion times better, and skylights? Yes, they are in the exact same courtroom. It's just the court is running the cameras now and not the media. So thank you guys for all of the compliments. Who the hell are all these witnesses? Aaron? I mean, they're not going to call all of those witnesses. They're just not going to get there. But if you're looking, I mean, this was a massive crime scene. So you're looking at like the entire, I'm sure, Moscow, Idaho Police Department, the FBI, other law enforcement from when all the search warrants were done at Bryan Kohberger's place, and then all the law enforcement that did the search warrants at his office, and then everyone who did all of the DNA. It can be a lot. It can be a lot. Fun and Funky says, cute, but what is an Eevee? It's a Pokemon. Mm-hmm. We nerd strong in the law nerd community. Come to Melbourne, good coffee. That's one of the number one things I've heard about Australia is that the coffee will ruin you for life for the coffee everywhere else. So people in Idaho scheduling surgery for June. Yeah, of 2025. They're like, my shoulder feels a little funky. Let's see. Which potential jurors to be afraid of being in the jury? I don't know. EDB, did you see Kyle Richards on We Are Family Wednesday night? I did not. I am behind on TV. But you know what I did watch last night and really enjoyed because I was influenced by Not Skinny But Not Fat, because on her Instagram stories, she posted that she was going to watch the Kelsey documentary on Amazon. Totally watched it, really enjoyed it, cried a lot, like more than I think is healthy. Cried a lot, but also had some. I just cried a lot. It was really, really good. I really enjoyed it. Team up with Peter, Rob, Natalie, Runkle, and whoever else can stream for a day or two of the trials. Gives everybody the views and a well-deserved break. Jen B, I get compulsive. So unless I absolutely had to travel, I had to travel during Depp v. Heard and I fucking hated it. I was anxious the entire time. So no, I will, if I decide to gavel it, I will probably gavel it unless something happens, which will be exhausting, but we'll see. Let's see. Walkie Talkie said, I commented earlier, I wanted you to know of that the people I have recommended to your channel have sent me merch to say thanks, loving it. Walkie Talkie, that's so sweet. And sweet of your friends to be like, thank you. So the more law nerds, the merrier. Coming to Maine for the summer. Maine's beautiful. I really appreciate how both Ann Taylor and the prosecution went out of their way to give grace and concession to each other. That's rare. It is nice to see that they are not just at each other's throats. The younger defense attorney Longston tends to get a little more hyperbolic, which I can understand. Ann Taylor is a seasoned attorney, and she is like, I'm going to give deference to the prosecution. This is not all their fault, but these are the problems I'm facing. I thought she was great. I think Ann Taylor, I like the way Ann Taylor lawyers very much. And I think a jury is going to want to listen to her and will like her very, very much. I can understand that they need to go through all 51 terabytes before being able to get fully prepared experts. Yes, which is a problem. I'm confused. Peace Dog, this was such a great question, and I appreciate it. I'm confused. How were they all going to be ready this past October when it was first scheduled to begin, but now they're not? They weren't going to be ready. They weren't going to be ready. But if the defendant doesn't want to waive his speedy trial rights, there's not much they can do. The defense could have said, I am not prepared. But I think the defense said that to Bryan Kohberger. There is no way we can actually give you a great defense if you're ready to go to trial. We just have to sit here and react to what comes at us. But if you want us to do a great trial, we need more time. And I think that's why he ended up waiving speedy trial. So no, they weren't going to be ready. It was going to be a clusterfuck. Question, why don't they want to give up their right to speedy trial? They already did give up their right to speedy trial, and they want this trial to go into 2025. Do you miss the courtroom, Emily? No, I love being able to zoom in and not feeling like I'm constantly running late and sitting in traffic. No, I love getting to do this. Does every major criminal case have the same issues? Janine, I'm sorry. My brain has gotten tired after streaming all week. Not issues like this. This case has a tremendous amount of data. It is essentially 4 homicides, being a quadruple homicide. It has, I'm sure, a tremendous and intense amount of crime scene footage, body cam footage. Like every officer that showed up at that crime scene every single time has body cam footage, right? So that's potentially hundreds of hours of body cam footage. Then they've got all the security footage of waiting for a white Elantra to drive by. There's just a tremendous amount of information. So no, not every case has this problem. We've had cases go to trial, in a minute, and it's like, oh, here's the file. There's this much evidence. There's the witness over there. And the witness is like, that guy stabbed me. And then you're like, okay, how do you know it was him? Well, I'm looking at him and he walked up to me and stabbed me. And it's like, okay, well, was this you after you were stabbed? Yes. I mean, there's not much more to that trial. Other than that, the defense attorney questions that person. You ask the officer, did you arrest that guy after he stabbed that guy? Yes. Okay. And you can do a trial in a half a day. This is very different than that. And there's so much digital evidence. And then they dumped multiple computers, like a Fire Stick and cell phones and stuff, and then car black box stuff. There's a tremendous amount of digital evidence, and then all the DNA evidence. It truly is a lot. Thank you. Camilla, my nephew was successfully born via emergency C-section. Congratulations. Well, I wish no one an emergency C-section. I've been there. Hopefully everyone is well and healthy and getting some sleep. These are from way earlier in the day. How can the defense not see what evidence was put forth? What if prosecutors lied during the grand jury? This makes no sense to me. Mike, this is a great question. The grand jury transcripts the defense has. So they have it. They've seen it. They know it's been presented. That is not information for the public. That is why those things are sealed. So Mama Wolf said, please remember, overall, he is still innocent until proven guilty. I hope the trial moves forward sooner rather than later for the victims' families. Always a good reminder. Jilly Bear, good to see you. Almost a year for Seashell. Congratulations. Bookmouse said, question, the chat moves that Judge John Judge henceforth be referred to as J3, aka J cubed. May we have an official ruling on the bench? Ruling from the bench. You may call John Judge J3, J cubed, or Triple J. You guys can pick. Or any of the above. You can use them synonymously. I agree with you, chat. The audio was better today. I like the court doing it. I talk about law nerds so much. My friend sent me merch to say thanks. I love that walkie-talkie. I do get through these back at the end of questions. Is Ann Taylor saying 12 to 15 week trial to force a change of venue? No. I think that's their time estimate, knowing what they want to present as the defense. So who's the lady updating her emails at the bottom? One of the defense attorneys. That's a lot of evidence. What could that mean? It means it's a lot of evidence. Body cam footage from all those officers is going to be a lot to start with. 51 terabytes. First time I'm hearing that much data evidence in a case. It's a lot. Why did they wait until now to talk about this and how this affects timing? They've been talking about this in motions since the beginning, Bella Vita. This has come up over and over again, and they still don't have all the evidence. Casey Cat, Emily, I worry jurors will feel the same way after the Murdaugh jury and the Maya jury. I certainly think twice, and I've already served on 2 big juries, including a quad murder. I do think the way that jurors have been interrogated after trial is a concern, and it concerns me. I want to do a podcast episode talking about it. I just haven't had time. I want to do it. Is all of that required at trial, though? All of the 51 terabytes of evidence, Sharon, aren't required at trial, but the defense has to know everything that's in there in case there is something that they need. The 3 generations has to do with the IgG stuff. Rowan, the way she was talking about the 3 generations, she was also talking about it in mitigation and wanting to go back multiple generations in mitigation. Question, since the defense is arguing there's so much discovery, would they be able to use AI to go through those files? Is that against the rules? Brian, I don't know what the ethics around using algorithms to help sort evidence would be. At the end of the day, she still has to go through all of it herself. So even if they could get a summary, she still has to look at every single bit of it ethically. Well, she or someone on her team, and that's hard. Opposite issue of needing more time. Yeah, Murdoch. As soon as she's mentioned officers, I don't know what that one was. Hamster Mom said, my toddler was recently diagnosed with autism. EDB and the community have helped me realize that being neurospicy is not as scary as you see on TV. Yay, Hamster Mom. We have lots of AUA. I always say it wrong. AUHDAD. Gosh, I'm too dyslexic. The autism ADHD community. I can write it. I clearly can't say it. We have lots of folks in that community, and there are lots and lots of delightful quirks that come with having neurospicy kids. And hopefully this community can give you tips and tricks so you feel like you are supported. But also there are lots of places for support, and understanding your kiddo is so valuable to helping them feel like these are just the quirks on how they work versus anything to be worried about or have to hide or have to compensate or mask for. And I love that this community is so open about their own neurospicy quirks. If it's summer 2025, does that mean no Dave for you? No, Deb, no. It means we're going to work it out. Concerts are at night. We're going to work it out. Emily, are you catching DMB at Bourbon and Beyond? I'm not sure yet. I need to look at my schedule. We've got some family stuff that we're waiting on for the summer. Moon Magic Mayhem said, on a lighter note, I just found out I'm expecting baby number 4 the day before my wedding anniversary. 2024 coming in strong. Congratulations on number 24 and the timing. It's fantastic. Let's see. So for all of you, ADHD, I thank you, a tired millennial. I couldn't do that well at all. Wonder if my boss will give me 15 weeks off to watch the trial. Yes, you're on jury duty. Excuse me, boss, I'm on jury duty. Are you a deliberating juror? No. I am an internet juror, but a juror nonetheless. Let's see. Does 12 to 15 weeks include jury selection? It probably should. But it depends on the attorney if that considers jury selection or not. So with all of that, chat, I am tired. I have to record quick bits. The more tired I am, the more difficult quick bit recording is, because the more difficult it is to be quick. But I need to record quick bits and go see my family before my kiddo has to be back at practice this evening. I appreciate all of you for being here. If you do not have the Lawnerd app, you need it now. We are streaming on Monday. I think I have a chiropractor appointment in the morning. And so we've got to do all of the things. What is this breaking news? Hold on. I never do breaking news. Breaking: Kat Von D's Miles Davis tattoo didn't infringe on photo. A California federal jury on Friday cleared celebrity tattoo artist Kat Von D. I will probably cover that in a podcast episode coming up. So that has resolved. So yes, I will cover that coming up. I was waiting for it to resolve so we could explain it. All right. With all of that, Lawnerds, get the app. We are going to be here Monday. I don't know what time yet. I need to look at the court schedule, and I think I have a chiropractor appointment. My neck has not been right since I traveled. So that'll be in the app, and I will post the live stream up here in advance of that, so you know. So with all of that, Law Nerds, you're the best. You're the best. It's good to see you. Thank you for being here. Thank you for being a Law Nerd. Thank you, Streamyard, for our Q&A music, and for such an amazing platform to stream on. I love it. And I will talk to all of you in the next one. Have a great Friday, guys.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a Law Nerd.